hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today, let us learn about state and its recognition. The acknowledgement of the status of an independent state is called recognition. Recognition is a process whereby certain facts are accepted and endowed with a certain legal status like statehood, sovereignty over newly acquired territory, or the international effects of the grant of nationality, all of these. In this process of recognizing a state, a new entity that conforms with the criteria of statehood is the political factor. Each country deciding for itself whether to extend such acknowledgement or not. Generally, sovereign and diplomatic immunities are generally extended only after a state's executive authority has formally recognized another state. The international recognition is an important evidence that the factual criteria of statehood actually have been fulfilled. So, for a state to have its recognition, it has some requirements. According to Article 1 of the Montevideo Convention, the minimum requirements of statehood are: it should have a permanent population, well-organized government, definite or fixed territory, capacity to enter into a relation or an agreement with other states. Some jurists have given certain definitions regarding the recognition. Recognition is defined as a formal acknowledgement by existing member of the international community of the international personality of a state or a political group. J. Jessup has defined a political community acquiring or satisfying the requirements of the statehood and qualifying itself to the member of international community is a state recognized. Professor Oppenheim said that in recognizing a state as a member of international community, the existing state declares that in their opinion the new state fulfills the condition of statehood as required by the international law. Oppenheim, who was the father of international law, gave famous theory of recognition in the international law. The given statement of him has given rise to two theories of recognition. They are constitutive theory and declaratory or evidentiary theory. Recognition in his term refers to the acknowledgement of one state by another state. However, international law is soft law and doesn't impose obligations on any other states. The constitutive theory has been adopted by Oppenheim himself, and he states that state can come into existence and become an international person only through recognition by other states. This theory was applied widely during 19th century for coming into a consensus on acceptance of states and were used until last 1973 to recognize East Germany by the Western countries. The declaratory theory, on the other hand, states that any state that fulfills the criteria of statehood as per the political definition is a state which is recognized. Constitutive theory. This recognition is a process whereby state is constituted. We have certain jurists who propounded this theory. Hegel is one of the pioneers of this theory, and it is supported by Ancelotti, Holland and Oppenheim. According to Ancelotti, he says that the rules of international law have grown up by the common consent of the states, and it is a subject of international law that comes into being with the conclusion of the first agreement as expressed by the Treaty of Recognition. Such recognition is reciprocal and constitutive, creating rights and obligations which does not exist before. So, which are the rights which not exist before? After recognition, it becomes a recognized state. According to Holland, a state cannot be said to have attained maturity unless it is stamped with a seal of recognition, which is indispensable to the full enjoyment of rights which it connotes. According to Oppenheim, a state is that which becomes an international person through recognition only and exclusively. So, according to all these jurists, and which includes constitutive theory, statehood and participation in the international legal order are compulsory to attend by the political group only insofar as they are recognized by the established states. According to this constitutive theory, recognition gives the rights and duties to the recognized states under the international law. The recognition of Poland and Czechoslovakia through the instrumentality of treaty and Versailles lends the support of constitutive theory of recognition. This constitutive theory has little criticism. Constitutive theory has been severely criticized by many jurists, and it has three defects. The first defect is that obligations by all the states. Practically no states like to have such obligations imposed on it. The primary characteristics of recognition is political and diplomatic but not legal. And this first defect was announced by Judge Lauterpact. Edward Collins point out second defect. He says that the practice indicates, however, that all the established states normally recognize new states and new government that in fact exist. They have not consented to law norms and obligate them to do so. The third defect arises when a state is recognized by some states and refused by some other states. So these are some of the criticisms with respect to constitutive theory. So according to constitutive theory, states have rights and duties only upon its recognition. Recognition means complete recognition by all countries. For example, Palestine has no definite territory, population and definite government. Still it is recognized by 18 nations including India. Bangladesh was recognized first by India and later by Soviet Russia immediately after it is formed. But China and Pakistan recognized it after 2 or 3 years after its birth. Declaratory or evidentiary theory. Declaratory theory is also called as evidentiary theory because it requires some evidence. It is exactly reverse of the constitutive theory. We have certain jurists who explain about this declaratory theory. According to Professor Hall, the state which is theoretically a political is organized community enters as a right into the family of states and must be treated according to the law as soon as it can show the marks of statehood, and no state has the right to it with whole recognition when it was being earned. According to Brierley, the granting of recognition to a new state is not constitutive but a declaratory. It does not bring into legal existence a state which does not exist before. A state may exist in fact, whether or not it has formally recognized by other state, it has right to be treated them as a state. So in conclusion, we can say recognition is a status of political community. Whether it is constitutive or declaratory, the two theories have some kind of imperfections and criticisms, but these two have little definitions regarding the state and its recognition.